India's Personal Data Protection Bill, PDP, versus GDPR by Indian Cybersecurity Solutions. Scope. The scope of sensitive personal data is much broader in the PDP than the GDPR. The PDP provision regarding critical personal data has no appropriate parallel in the GDPR. PDP names three categories of data: personal data, sensitive personal data, and critical personal data. The PDP authorizes the central government to define and determine the nature of critical personal data and recommend new categories of sensitive personal data. There are also provisions to exempt certain government entities from the bill. Residency and cross-border data flow. GDPR mentions that data must be stored in an identifiable form for a certain length of time. Any extension in the storage period would be pursuant to certain exceptions. These exceptions include the use of the data for scientific, statistical, historical, or public interest purposes. Under the PDP, data can only be stored for the period of time required for it to satisfy its purpose. Once it has served its purpose, it must be expunged. Any case where the data is to be retained for a longer period of time requires explicit consent from the data subject under the PDP. Consent and notice. GDPR requires clear notice regarding the collection of data. This notice needs to be simple and easily understandable. It also needs to include details about the relevant data protection officer or DPO and the identity of the data controller, among other things. GDPR also requires valid consent before the data is processed. Valid consent is consent that is specific, informed, given without ambiguity, capable of being withdrawn at any point, and given freely without coercion. The PDP replicates the notice requirements of the GDPR and makes further additions to it. These additions include notice being available in multiple language options and the inclusion of any other information asked by the DPA, including data trust scores and reliability ratings. The consent requirements are also similar to GDPR, with the addition that sensitive personal data would be processed only when there is explicit consent. To help oversee the consent of the principals better, PDP also introduces a new entity called Consent Manager. Data processing. Under the purview of GDPR, certain principles are attached to data processing. These include fairness and transparency, lawfulness, purpose limitation, collection limitation, storage limitation, accuracy, integrity, confidentiality, and accountability. Here there are some interesting differences with the PDP. While the principles of data processing under the PDP are similar, the bill also adds other grounds, including needs related to employment and other reasonable purposes as decided by the DPA. Contract performance, while a ground for data processing under GDPR, is not considered valid ground under the PDP. Also, all grounds for processing personal data under GDPR carry equal weight. Under the PDP, the primary basis is consent, and all the other parameters are considered exceptions. Compliance and security. GDPR specifies data protection by design. Data controllers and processors are required to enforce the proper data security measures for any kind of personal data. Controllers are also obligated to carry out data protection impact assessments or DPIAs before processing certain kinds of personal data. Data protection audits can be employed to investigate data controllers and processors. In these measures, the PDP remains very similar to GDPR. Audits, privacy by design, and DPIAs are all included in the PDP. However, there are some differences regarding the approach. GDPR obligates all data controllers to carry out DPIAs and maintain all records of data processing activities. In the PDP, this is only a requirement for significant data fiduciaries. Data breaches. In the event of a data breach, GDPR specifies that data controllers would need to provide notification to the relevant supervisory authority within a maximum period of 72 hours. If there is a change of harm coming to the data subject, the subject also is required to be notified as soon as possible. Under the PDP, data fiduciaries are only required to notify data principals if they are instructed to do so by the DPA. In such cases, the DPA determines the need to notify based on the degree of the potential harm the data subject can face. This is the main point of difference from GDPR, where every breach needs to be reported to the supervisory authority unless there is a negligible chance of risk to the data subject. Data processors. Both GDPR and the PDP have provisions in place regarding the employment of data processors. Under GDPR, only compliant data processors can be employed by data controllers. The eligibility of a particular data processor is determined either through adherence to an approved code of conduct or through certification. A data processor would need clearance from the data controller before employing another data processor. In the PDP, it is specified that data fiduciaries can employ a data processor using a valid contract. The contractual requirement for a data processor is a lot more relaxed than mentioned in GDPR, where data processors have to furnish sufficient guarantees of their adherence to GDPR before they can be contracted. The PDP also does not require DPAs to specify standard contractual clauses between data controllers and processors, whereas GDPR allocates the European Commission with the authority to recommend such clauses. Data storage. GDPR mentions that data must be stored in an identifiable form for a certain length of time. Any extension in the storage period would be pursuant to certain exceptions. These exceptions include the use of the data for scientific, statistical, historical, or public interest purposes. Under the PDP, data can only be stored for the period of time required for it to satisfy its purpose. Once it has served its purpose, it must be expunged. Any case where the data is to be retained for a longer period of time requires explicit consent from the data subject under the PDP. Automated decisions. In cases where personal harm can ensue from an automated decision-making process, GDPR has clear and stringent provisions. While a large-scale profiling is said to require thorough assessment under the PDP, the bill does not allocate any rights to individuals to object to automated profiling, with only children being exempt. The GDPR covers this ground much more thoroughly, mandating that data subjects can object to automated profiling for the purpose of direct marketing. GDPR also mandates that this right to object be conveyed to the data subject as clear and distinct information. In conclusion, while the GDPR does seem to be a template for the PDP, there are significant differences that make the Indian PDP a clearly unique entity. While some existing issues with the PDP are likely to be corrected as the bill evolves, it would definitely be interesting to see the implementation of the PDP and how different entities manage to ensure compliance going forward.